recent regulatory and legal updates. Friends, as you are aware that every month, first Friday, we are doing change. We are just recapping the recent regulatory changes and legal updates. And it is really indeed an honor to have all of you today to discuss the latest updates and regulatory changes in the field of company, securities and insolvency law and FEMA law. As friends, you are aware that these three to four areas are very crucial for smooth functioning of business and its economy. The current legal landscape is ever changing, and it is imperative for professionals in this field to keep up to date with the latest development and regulatory changes. That's why we at Corporate Professional try to do this, that whatever you have missed out in the entire month, so the first Friday of the last month to this first Friday of this month, whatever new changes we have seen in the market, we have regulators have brought out, the law makers have brought out, that we are discussing, and some important case laws we want to discuss on these topics. Today, our very expert panel is there, who they are comprising of regulatory specialists who will share their insight and experience on latest legal updates and regulatory changes in these area of laws, because every day and night they are doing work on this. They study this, they give knowledge to other people also. So today we all will discuss, and they will discuss the impact of these changes on business and economy, and what was the earlier law and what is the present law, and how we should take care of these things, and what are the important legal issues, legal confusion that is there. We will discuss and threadbare we will solve this. So I extend a very warm welcome to Galaxy of speaker for today. First, I will welcome Mr. G.P. Madan, who is a founder of Madan Law Office and M&A Task Force co-chairman of SOCHM. Then we have Amit Gupta, who is a practicing company secretary and insolvency professional. I welcome G.P. Madan and Amit Gupta. Then I have Anjali Agrawal. She's partner and head capital market and in corporate profession. She will look after the capital market related changes in LODR and other things. Then we have Ankit Singhi, head corporate affairs and compliance of corporate profession. He will discuss with AIF and the LODR changes. So friend, today we will discuss all these things, and I'm sure that the webinar will provide a valuable input for learning and discussion, and we hope that it will help us to gain better understanding of the recent regulatory and legal updates in the field of company and securities and insolvency law. I also welcome Devashri Das. She's senior associate corporate professional, and she looks after the FEMA related changes. So I once again welcome all of you and hope that this will be very informative and engaging. And before I will start this program, I will request Ankit Singhi, because we have recently launched our book on company law, Ready Referencer. So to request second edition, request Ankit Singhi to just explain.
So good evening, everyone. Welcome all the participants. And today is a happy moment for corporate professionals. So we launched the second edition of our company law Ready Referencer. It's updated up till 30th June 2023. So it's a Ready Referencer. The name suggests it's a book where you can reach out to for various things in a readily and easily tabulated formats and well presented data information. There are more than 120 handy head referencers in form of like resolutions, eligibility, exemptions. There are a lot of things that we do require at SPDs instantly, and at times we need not to go into the BAR Act to find out the exact place what is mentioned. Those are the Ready Reckoner, considering the key requirements as a professional, as a company secretary in a corporate, what kind of information we generally do require from time to time and which should be handy. So it gives you that handy approach in form of the Ready Referencer. This is the second edition. and it's already available on the Amazon store and other leading book publishers. I hope you will find it useful for your purposes.
So thank you very much, Ankit, for telling about this book. So this book is available. You can use it. Very valuable and very informative. So now it's a time to go for recap on recent regulatory and updates. Friends, I'll request all the participants that they should, when this discussion is going on, they can just raise their points, raise their queries. So we will give answer during the discussion. So first I will request Mr. GP Madan, because there are so many so many things has come. Like one discussion paper amendment in IBC is there. That is very important and very, if there are so many changes they are proposing. So just request Mr. Madan to discuss this discussion paper or amendment in IBC. Over to you, Mr. Madan.
Thank you, Mr. Pawan. Good afternoon, all my co-panelists and all the participants who have joined this webinar. First of all, I think my apologies. Was there any disturbance from my side to begin with?
Yes, you have. I think you were listening to Mr.
No, I was not listening. Some other side got opened. I don't know, and I was thinking it is coming from your side.
Okay.
So I was just waiting for you will close it. Then when you started speaking, that I really thought it was a mistake on my part. My sincere apologies for that. And my heartiest congratulations to you and your entire team for this ready referencer. This is another milestone, another feather in your cap. Congratulations.
Thank you, Madan sir.
Can we delete this PPT for this purpose? Because I'll be discussing the recent discussion paper of IBBI. Friends, as we know very well that this particular legislation, Insolvency and Bankruptcy Code 2016, is one of the most dynamic legislations. In addition to this, I consider two more legislations very, very dynamic. One of them is Companies Act 2013, and another is GST 2017. Now, since the inception of this law, IBC, we have seen at least 5 major amendments in the code. We have seen hundreds of regulations which have been introduced by Insolvency and Bankruptcy Board of India, the regulator. And in addition to that, we have seen enormous amendments to the existing regulations. But one thing I admire about IBBI is that whenever they come out with any amendment in the regulations, because the regulations can come only from IBBI. As you know that in IBBI, they have used two terms. One is as may be prescribed and as may be specified. As may be prescribed means prescription by way of rules which can be done by Ministry of Corporate Affairs. And as may be specified is MCA. Sorry, as may be prescribed is MCA, and as may be specified is by way of regulations by IBBI. So whenever IBBI brings about new regulations or makes changes to the existing regulations, IBBI every time comes up with a discussion paper, throws out open to the stakeholders for the discussion, receives their feedback and suggestions, and on the basis of the feedback and suggestions, the amendments to the regulations or the new regulations are introduced. Similar has been the case here that last month, on 7th of June 2023, IBBI came out with a discussion paper with respect to the amendments to CIRP regulations. CIRP regulation means Corporate Insolvency Resolution Process for Corporate Persons. So IBBI is proposing to bring certain changes to these regulations on the basis of the feedback which has been received from the stakeholders, or wherever the stakeholders were receiving hardships or difficulties in implementing the resolutions. IBBI proposes to do away with all those difficulties and hardships, and now IBBI proposing certain changes in the CIRP regulations. The last day to submit the feedback or suggestions was 27th of June 2023. I, as chairperson of NCLT and IBC Committee of PhD Chamber of Commerce and Industry, have already submitted my suggestions to IBBI. So during the course of this next 10-12 minutes, I'll be discussing some of the gist of these proposed amendments, and wherever it's required, I'll share what suggestions we have given from the chamber or I have given from my side. One of the proposed changes which IBBI is proposing now is with respect to assignment of debt during CIRP. If during CIRP a debt is assigned, existing regulations say that intimation of the assignment or transfer of debt shall be given to the IRP or RP as the case may be, but there was no timeline for that. Now, IBBI is bringing a timeline for that purpose, and the proposed amendment says that within 7 days of assignment or transfer, both the parties, the transferor or transferee of the debt, both the parties shall intimate about this transfer to the IRP and RP as the case may be. So this is one of the amendments. Second amendment which is being proposed is to strengthen the hands of IRP and RP with respect to the collecting of the information and taking over the records from the directors and senior management of the corporate debtor. Because it has been observed that whenever a company goes into CIRP, in majority of the cases, the existing management or the directors, they do not cooperate with the IRP or RP. And for that purpose, IRP or RP is filing an application under section 19 subsection 2 of the code with respect to seeking cooperation from the directors, promoters or senior functionaries of the corporate debtor. Secondly, whenever a company goes into CIRP and there is no cooperation, it is very difficult for the IRP or RP to make a list of the assets which are being taken over by him. And if the list is not there, if the assets are not there, it's very difficult to get the valuation of the assets of the CT done. So now the proposal is that all these functionaries, senior functionaries of the corporate debtor shall provide the support to the IRP or RP. A list shall be prepared, list of assets which are being handed over shall be prepared. The list shall be signed by both the parties. In addition to that, whatever assets are being reflected in the balance sheet of the corporate debtor, the latest available balance sheet of the corporate debtor, the IRP or RP shall prepare a list of that and will ensure that all those assets are handed over to the IRP or the RP. So with respect to the handing over of the assets or taking over the assets, the hardships which were being faced in the system, there is an attempt to do away with all those hardships. And I think this will actually, once implemented, this will curtail the CIRP period. And so that the resolution, the valuation can be done at the earliest, information memorandum can be prepared at the earliest, and there can be early resolution of an insolvent company. The third proposed amendment is with respect to modification of timelines for submission and consideration of claims. Friends, as you know, the existing timeline for submission of a claim is 14 days from the date of company goes into CIRP. In addition to that, an extended timeline has been provided of 90 days from the CIRP commencement, within which further claims can be submitted along with the proof of the claims. But what will happen after 90 days? As on date, the practice is, earlier the practice was that RP was admitting all the claims. Before the resolution plan is approved, whenever the claim is filed, RP was admitting that. But later on, last year, we had one major pronouncement from NCLAT that if a claim is submitted after 90 days, the RP cannot consider that claim. So in that case, the claimant has to go to adjudicating authority and file an application for condonation of delay in filing the claim. Now it is being proposed. Actually, what happened in one of the cases, I filed an application on behalf of all those claimants who filed the claims late. NCLT told me, what is your locus as RP? You don't have any locus. But said, I want to facilitate. But NCLT said, no, sorry. Let all the claimants come to us and file an application for delay condonation. And now, can you believe it? The proposed amendment says RP shall file an application on behalf of all those claimants who have filed their claims late. And this application shall be filed for condonation of delay. And in this application, the RP shall segregate all these delayed claims in two categories. One is admissible, another is non-admissible. And these two lists shall become annexure to the application to be filed by the RP. And then the adjudicating authority shall take a call that whether in all those cases wherever the claims are admissible, delay should be condoned or not. And in case wherever the RP prepares a list that these claims are non-admissible, RP shall give a reason that why these claims are non-admissible. Till date, there was no particular provision that RP has to give the reasons. But now the reasons, communication of the reasons is also mandatory on the part of RP.
Sir, can I interrupt?
Yes, please, Ankit.
Just want to understand, sir, what if, is there also a timeline for filing this condonation application by the RP? Till how long he has to wait?
Fantastic question, but I think this timeline may be provided in the proposed regulation. So far, the regulation which has come, there is no timeline for that. And it's a very good point. I think I may write to IBBI again that even for filing of this application, a timeline may be provided.
And so once I file this application and thereafter I receive further claims, so long as I continue to receive these claims, I have to file them for condonation?
These regulations will take care of that.
Because is there any discretion on the part of RP or not? Whether if you don't want to file,
no discretion, or RP will be time bound as per the timelines provided in the regulations.
So then this will.
Further, this filing of the claims up to the 90 days, this timeline is also being extended till the time of issue of RFRP.
Okay.
Till that date, if a claim is filed, RP will have to entertain that claim. So 90 days period will be removed and 90 days shall be replaced with the date of issue of RFRP shall be added, substituted. The next amendment which is being proposed is with respect to increase in the duties of authorized representative. Wherever there are financial creditors in a class, particularly the home buyers, they are appointing one authorized representative. But till date, the AR's duties are not their part of the regulations. Like you see, we have section 166 in Companies Act duties of directors, though they are implied duties. But they have been made part of the law because if there is a violation of any of those duties, it becomes an offense. Similarly, now the duties of AR are also being introduced in the code. Till that there were no duties which were prescribed. And AR now will be acting as per the duties prescribed, will act as a bridge between the COC as well as the RP. He will act as a catalyst in removing the difficulties, if any, being faced by the financial creditors in class. And he will also represent the financial creditors in class before NCLT, NCLAT, or any other government authority. So that will be his duty now. Further, it is also his duty now to hold regular meetings, not a COC meeting, but regular meetings with the financial creditors in class. And for this purpose, there is a proposal to pay him some fee also. So if you ask me personally, I'm not happy with the fee, the level which has been proposed. And from the chamber, I have proposed much higher fee to be paid to authorized representatives.
Similar to a director, he would also be liable if he fails to perform any of these duties?
Absolutely. Absolutely.
So then,
yes. Yes.
He may be subject to more litigation.
Yes, and IP needs to think twice before he gives his consent to become an AR. Now, there are existing fee structure for an AR to be there in a COC meeting. All those fees being doubled. 15,000 ki 30,000 kar di aur 25,000 ki 50,000 kar di. What I have proposed, this fee should not be as per the meeting because it's not a sitting fee. If you are giving him duties and he has to perform his duties throughout the CIRP cycle, why fee is linked to the meeting? He should be paid a monthly fee. Then there should be some minimum fee for that purpose also. And our proposal, 1 lakh of rupees per month should be paid to AR. And then in addition to that, a sitting fee for this meeting, which he is going to have with the financial creditors in class, which are not COC meeting. A very, very meager fee for that is also being proposed for 10,000, 12,000, and 15,000. Further, as on date, there is no provision for replacement of authorized representative. The law is silent on that. So whenever there is any technical problem, suppose an authorized representative dies, or he wants to submit his resignation, or financial creditors in class, they want to remove him. There is no such provision. Now a proposal is being made in the regulation that if 10% of the financial creditors in class, if they so desire, they may move a resolution, and then by passing a resolution, this AR may be replaced or removed, and some other IP may be appointed as AR. Another proposed regulation is with respect to insertion of minutes of the meetings in which the resolution plan has been discussed with Form H. So what is Form H? Form H is nothing but a compliance certificate to be given by the resolution professional, and which shall be annexed to the application to be filed with NCLT for approval of the resolution plan. Now, all the minutes with respect to those meetings where resolution plan has been discussed, all those minutes shall be annexed to Form H, and Form H shall be annexed to the application for approval of resolution plan. The sixth, there are total 9 proposed amendments. The sixth proposal is with respect to limitation. Though there is section 238A in the code which says that the law of limitation shall apply to all the applications to be filed under IBC. But now IBBI wants a special insertion in the application itself, particularly in section 7 application, that this application is not barred by limitation. And for that purpose, the entire sequence of the loan from the date of sanction till the disbursement, or any notice being issued, any reply being received, all those for communication correspondence shall be annexed, and then there shall be an affidavit with respect to this, that this application is not barred by law of limitation. Though what we have given a proposal that it should become part of the form, not by way of a separate affidavit. When this application is in the format, so let there be one particular column be inserted in the format itself, or that application is not barred by limitation. The seventh proposal is, and we professionals are very well aware about that, whenever we go and cast our vote in our institute's election, there is a real system of preferential voting. How the votes are cast and how the votes are counted. Same proposal will be there now in respect of resolution plans. So if there are more than one resolution plan, plan 1, 2, 3, 4, so it's not that whichever is getting the highest one, that should be approved. No. Suppose we need 66%. Plan 1 is getting 60, 2 is getting 50, 3 is getting 40, 4 is getting 30.
Madam sir, but this is very complicated process of voting.
Sir, I have communicated to IBBI that an institute we used to call our Rajya Sabha's representatives. And so far, we have not been able to develop a software for this. So how IBBI is going to handle it, I think maybe along with the regulation, they may bring something which may be ultimately used by the professional bodies. So that system is going to be introduced. Proposal 8 is with respect to some, there was some grammatical error, typographical error in the existing regulation. So that is going to be removed. I'm not going to discuss it. The 9th, the last but not the least proposed amendment is with respect to audit of CIRP cost. The RP has incurred certain expenses during CIRP process. Now IBBI wants an audit of this cost should be done, and this audit should be done by a chartered accountant who also happens to be a insolvency professional. Now I have given a suggestion that under Companies Act, when internal audit can be conducted by a cost accountant and also by a practicing company secretary, that why not this audit of CIRP cost can also be conducted by any of the 3 professionals? Why should it be restricted to one particular profession only? To begin with, when I met IBBI executive director, he was in line with me and he said, yes, certainly they will consider it favorably. And once it is there, certainly it will be another opportunity for the company secretary in practice to being an auditor for the CIRP cost in the CIRP process under insolvency and bankruptcy code. These were some of the gist of the proposed regulations from my side. If there is any question, I'll be more than happy to address it.
Okay, thank you very much, Madan, sir. I think the most important which they are saying, it has an advantage also of the preferential voting, because the plain number will replace with the different preferential voting. It has its own advantage, but how the system they will run, because it's not a 3 years or 4 years election, it's every time in every COC or every resolution plan, it will be a difficult.
Even in case of a corporate debt, in case of a particular corporate debt, it can happen multiple times.
Yeah, that's right. That's absolutely. So let's see this. I think some of the good changes. Now, friends, in company law also, there are few changes because we are covering each and every changes which has come. So now I'll request Ankit Singhi that there are 2-3 changes there in company law. Please explain them.
I think, good evening again. The basic changes are with respect to certain extensions that have come. So like for DPT3, which was the last date was filing of 30th June. On account of the ongoing technical issues on the MCA portal, the date has been extended without paying additional fees is up to 31st July 2023. Similarly, CSR2, which is a form introduced last year and which was required to be filed along with the financial statement which are filed with the ROC. So like last year for 2022, the last date of filing of AOC or CSR2 was extended to 31st March 2023. So similarly for 22-23, the last date for filing of CSR form has been extended on or before 31st March 2024 next year. So once you file the annual financial statement in AOC4 XBRL or AOC4 NBFC with the rest of the companies, you will have time till 31st March 2024 to file that form. You can also file it simultaneously after filing, or in case you are seeking external time, then you have time up till 31st March 2024 for filing this form. I think it must also be on account of the technical issues which are ongoing on the MC portal. Because all the data is generally prepared once you're filing the financial statement. So data which goes into CSR2 is already readily available with the company. So I don't see any reason why they would not be able to file that form either along with or just after filing the OC4. So the only reason one can see is on account of the issues that they may find while filing the form on the MCA portal. Now coming on to the LODR regulations, that is the main thing that is subject matter of our today's discussion. As we discussed last week, where we specifically focused discussion on Regulation 30 and the key changes that have been brought there. And today we'll go into sequentially on all the changes that have been brought under the LODR regulations, and we'll touch a bit on Regulation 30 just for a sake of the discussion. But since you already discussed that in detail, we'll not go much deep into those regulations. So otherwise also last month was very eventful in terms of LODR regulation, the SEBI board meeting, and a lot of other things happened on account of various changes introduced in FEMA, in NBFC related laws or AIFs and REITs and a lot of other things. And so it definitely was an eventful month. So beginning with, so the amendments are mostly effective from 15th June. The amendments that will be effective from 15th June. So there are two types of amendments which are effective from two different dates. So one is effective from the date the notification was published in the Gazette. So while the notification was dated 14th June, and generally we take the date of the notification as the date on which it is published in the official Gazette. But the amended copy of the LODR regulations that has been issued by SEBI on its website takes that date as 15th June 2023. So I believe the notification was finally published on 15th June 2023. So then there are certain amendments which are published on the date of notification, and then there are certain which were published from effective from 30th day from 15th. It's not visible. Is the PPT not visible?
No, I was thinking that you are just starting now.
Okay, I am sorry. I am sorry. No issues. So
just go to.
Yeah, I will. Hope it is visible now.
It is visible.
Yeah. So
just a minute. This is friends, as you are aware that we have discussed in last webinar Regulation 30. Some other part was not discussed because of today's program. So this is applicable from 15 June. So Ankit is explaining, and Ankit, Anjali, and Amit will discuss all these amendment in LODR. So Ankit, you give a presentation, then we will do.
And then the second amendment, as I mentioned, was effective from 30th day from the date of the notification. So while we thought it would be 14th June as the main effective date of publication, then 30th would be 13th July. So, but the date that have been finally found its place in the version of LODR, amended version of LODR released by SEBI, is the first amendment. Couple of amendments are effective from 15th June, and all others are effective from 14th July 2023. So I'll just go through with you in terms of the amendments that are effective from 15 June 2023, and then we'll go on to discuss the other amendments. So first is with respect to the requirement of high debt value. A couple of years back, high debt value regulations were amended. There was a concept introduced for high debt value listed entities of 500 crores or more, and large number of provisions of LODR with respect to regulation 2016 to 27 were made to apply them on comply or explain base, and thereafter it has to be adopted on a mandatory basis. So the last date of comply or explain was to end on 31st March 2023, and thereafter from 23-24 it has to be mandatorily adopted by all the companies which are high debt value debt listed entities. But now this further comply and explain exemption has been further extended to a year. So from 31st March 2023 to 31st March 2024. So still for 23-20 has been extended for comply and explain. So even during this year, you can, if you are a high debt value listed entity, then high value debt listed entity, then you can either adopt these provisions and undertake the compliance from regulation 16 to 27, or you can submit necessary explanations why you're not complying it. And then from next year, most probably 24 onwards, first April 2024 onwards, you will have to mandatorily adopt all these regulations if you are a high value debt listed entity. Then financial years for newly listed entities. So there was a lot of issues or confusion in the market with respect to newly listed entities. So for example, if for example, for financial result, annual financial result, the last day is 30th May. And if some entities is listed on 20th May, or if somebody is listed on 1st June, whether they are supposed to disclose the result of the financial year after their listing. And companies generally seek such guidance from the exchanges in respect to such disclosures. And to avoid any confusion, the amendment has been brought in the LODR regulations to very clearly provide that it has to be the last result, so far as last, for example, FY23 results, if not published as part of the DRHP, which was finally prospectus, which was finally filed with the SEBI, then post listing you have to comply with the 3 guidelines, and whichever is later. So either 45 days from the end of the date of the quarter, which is or 60 days as the case may be for a quarter and annual result, or 21 days from the date of the listing. So whichever is later, you have to comply with. So if you are listed, for example, on 5th April, then you have 45 or 60 days timelines you are available with you. And if you are listed after 45 days or 60 days, then you will have 21 days from the date of listing. So to declare the quarterly or annual results as the case may be with the exchanges. So this has now been clarified by way of necessary amendment under Regulation 33 of SEBI LODR regulations. Going further, so under Regulation 57, which was mainly applicable to debt listed entities or entities which have listed, I think, their preference shares. So they were required to submit a lot of disclosures on the end of the quarter in terms of the payments of interest or dividend, due date of payment or interest, then declare disclosure with respect to the payments, whether payments have been made or not. So there were a lot of disclosures that were required under Regulation 57, 1 day prior, 5 days, working days after close of the quarter. So now all of these being only A is now required to be submitted. As of now, B and C is being dispensed with by way of substitution of the Regulation 57. So now only this 1 day, one working day requirement is there, of where the interest dividend becoming due regarding the status of payment in case of non-convertible securities. This is something which the companies have now to intimate instead of the entire 3 disclosures that we were supposed to file within 1 working day, within 5 working days, beginning to quarter on 7 working days from the end of the quarter. Then another requirement, new introduction is made is with respect to the compliance that we do under Section 180 of the Companies Act under Clause A, where which deals with buy, sell, dispose of whole or substantially whole of the undertaking of the company. And there is a special resolution requirement which is there under the Companies Act. So for listed entities, now SEBI LODR regulation has tried to extend the compliance requirement and try to make it more stringent. So for example, in case a similar resolution is put in a listed entity where it wants to sell, lease, dispose of a whole or substantially whole of its undertaking, then it has to disclose the rational use of the proceeds in the explanatory statement, the purpose, why it is being done when the explanatory statement is being circulated to the shareholders. Section 181A doesn't outline any kind of disclosures that are specifically required. It is up to the company to disclose whatever they want. Now, the regulation 37A specifically provides you these specific disclosures under the explanatory statement. And apart from the special resolution, one additional requirement has been provided that public shareholders' vote should exceed the public shareholders' vote against the resolution. So, in case of a special resolution for a sale or disposal of undertaking under Section 180 for a listed entity read with Regulation 37A, two requirements: disclosure in the explanatory statement of the items specified therein in Regulation 37A, and then a special resolution coupled with the public shareholders' vote in favor of the resolution should be more than the against the public shareholders' resolution. And in case there are public shareholders who are directly and indirectly involved in the sale lease of the undertaking, then their vote will not be counted for the purpose of resolution under Regulation 37A. Then there are certain exemptions if there is the sale, lease, disposal is applicable is to a wholly owned subsidiary. But in case the wholly owned subsidiary intends to sell the undertaking, or the company intends to dilute the shareholding in the wholly owned subsidiary, then the same requirements that were required earlier if the listed entity is selling the undertaking directly, the same requirements will have to be complied with. So the objective of providing this regulation is that companies will not be able to circumvent by doing this, by transferring this in their wholly owned subsidiaries. And since the wholly owned subsidiary is not a listed entity, they can further sell that undertaking without complying with the Regulation 37 requirements under the LODR regulation. So if you're trying to sell the undertaking to a subsidiary, you have to comply with the provisions. If you are trying to sell it to a wholly owned subsidiary, you are not required to comply with the provisions under Regulation 37A. Under 180, you will still be required to obtain the shareholders' approval. But if that wholly owned subsidiary tries to part away with those undertaking wholly or substantially, or if the company, instead of selling the undertaking, try to sell the subsidiary by diluting certain percentage in the subsidiary, wholly owned subsidiary itself, in a way that it will not continue to be a wholly owned subsidiary, then in those cases, the requirement has to be complied by the listed entity by taking necessary approvals of its shareholders by way of special resolution, with public shareholders voting in favor of the resolution should be more than the shareholders who are voting against the resolution. And this regulation will not apply if the transaction is covered by any covenant pursuant to an agreement entered with the financial institution regulated by RBI or with a debenture trustee. So, for example, if you've taken a loan and where an undertaking have been mortgaged or hypothecated or something has been done, and as a result of the default clause, the requirement is triggering of disposing that asset, then the requirement of Regulation 37A will not be applicable and you will not be required to obtain the approval under this regulation. But as the banks generally do, while they do and when they enter into such kind of arrangements, they request company to obtain the prior approval of their shareholders under Section 181A. I don't know how, since it is not applicable here, whether in terms of governance, whether the banks will still force companies to ensure that the compliance is obtained as and when the approval is taken from the shareholders as an extended requirement of LODR regulations. Amit, Anjali, any suggestion, any view you have on this specific requirement? If Madan sir is available, he can also share his views.
First, Vishay can take Anjali's view, then Amit can add. Anjali, what is your take on these two regulation? Amit, you can start, then Anjali will. Anjali, you are there? Yeah, Amit, you start, then Anjali will add.
So Ankit, what I understand, this is a provision which was much expected because as such there was no restriction in the LODR with regard to the sale, lease, disposal of these undertakings. And now wherever checks were required in respect of when you were doing the M&A transaction and other things, those things were okay. But apart from that, the entities which are not governed by the maybe the Companies Act provision, they were unregulated as far as this provision particularly was concerned. Secondly, in the Companies Act, the restriction is little different, where as in terms of the LODR provision, the 37A that has been inserted, the sufficient checks have been incorporated, which were required to protect the public interest. That resolution shall be by way of a special resolution. Then also it shall be acted upon only if the public votes have been casted to get the approval, which is not the case of the Section 181A resolution. So I believe a change which is very welcome, and it was expected from long time why government has not inserted any these kind of provisions. So I don't see that there is anything which is more than that which is hidden. I can see that this is plain vanilla change which is well understood and reasoned.
Okay, and I think one of the reasons of this is also considering that in past some big listed entities have sold off their complete businesses to other business houses or to third parties, and there was no idea as to what and where, how this money will be used, and by using their own group majority, they were able to get those resolution passed, even though it was special resolution. So I think with the requirement of public being more than favor in more than the against vote, institutional shareholders now will play a key role in such transactions.
Absolutely.
Yeah.
Ankit,
Am I audible now?
Yeah.
This actually is a welcome change, more so required from the first to bring listing regulations in line with Companies Act provisions. So, and as Amit and Ankit said, this was a requirement, one of the important requirements needed to be covered with.
Okay. Next.
Okay. So moving along, I'll now take the other amendments which are effective from 14 July 2023. So first is with respect to the compliance officer. Now there is a specific, the regulation provides for appointment of compliance officer. There was no timelines which were provided in case of any casual vacancy in the position of a compliance officer. And since mostly company secretaries were acting as compliance officer and the company secretary of the company was acting as a compliance officer in almost all the cases, the regular, the provisions of timelines provided under section 203, that is of 6 months, was applied. But now this LODR has provided for a specific timeline of 3 months within which the position has to be filled. And in case they want to appoint someone as an interim compliance officer, then also it has to be appointed in the similar manner in which the original compliance officer would have been appointed, by following the regulations with respect to appointment of compliance officer in terms of qualification, the appointment process, and etc. I think one of the reasons is we have seen a lot of companies do appoint CFOs and some other officers as an interim compliance officers for the time being, in case of vacancies arising in the office of compliance officer. So since now it can be said that it has to be done in this same fashion. So in case of a compliance officer, it can only be a company secretary, not necessarily a company secretary of the company, which can be appointed, and necessary approvals has to be taken in accordance with the requirement of regulation 6.
So Ankit, if I understand correctly, are we saying that companies now may continue functioning even without a compliance officer for maximum period of 3 months?
Yes, they can.
So in this period, if a company chooses to appoint an interim compliance officer, now there are two situations. One, that company takes, let us say, 6 months time to fill the vacancy, and they have one deputy company secretary, and within 3 months or after 3 months, they are appointing that deputy as a compliance officer. So of course, they will have to charge him with the KMP position and take care of the other appointment formalities, and then only he'll be designated as a compliance officer. That is understood. Now, even during the period of 3 months where the vacancy is going on, which is permitted as per regulation also, do you think the restriction applies there also, where the law has given me a leverage that I may choose not to appoint anyone? Can I appoint CFO or CEO or any other person as a compliance officer during that interregnum period?
I think, sir, the intention behind interim compliance officer is with respect to the period when the original or the compliance officer which the company wants to appoint is not available. So even if the 3 months period is provided and they are giving you an option to appoint an interim person, that is basically for the time you are not able to finalize a candidate for acting as a compliance officer, not as an interim compliance officer. So it appears that the restriction is also not to allow appointments of CFOs as a compliance officer, even during the period of 3 months.
All right. So
then otherwise, because then it defeat the entire purpose of actually laying down this guideline of appointing an interim compliance officer.
So it is as simple. Maybe if you have not appointed or the companies which are in default, they'll whether you appoint or not, they'll continue to be in default of regulation 6. It is as simple as that. There can be
now, since they are giving you 3 months, so you cannot be said to be in default if there is a vacancy. If you have not filled that vacancy within a period of 3 months, you will not. Your default will only trigger after 3 months.
Now, Ankit, my only issue is that how the filings and other parts will be regulated, because during this period you need to have somebody for the purpose of uploading the document on the stock exchanges portal, right? So you will say that the person who is a managing director or a CFO, his signatures are being used for the purpose of filing the document, but still he is not to be considered as a compliance officer.
Then they will be filing in their capacity itself.
Their own capacity.
Amit, during the 3.
The voice is echoing.
Yeah. Is it okay now?
Yeah, now it.
Yeah. So during the 3-month period, probably the person, the CFO or anybody else can file the documents, but the requirement, because many companies what they were doing, they were just hiring somebody for the purpose of complying with the 3 months 6 months requirement. And then after 1 month again, the person used to resign, used to leave the company. So probably they have tried to plug in that requirement.
No. When they are saying, let us understand little more, where it says the listed entity cannot appoint an interim person unless the appointment follows the applicable laws for regular appointment to the position and fulfills the obligation. What does this sentence mean? What are the obligations for appointment of a person as a compliance officer? If we go to regulation 6, it only says that company secretary shall be a compliance officer. So if I understand correctly, if I correlate it with the provisions of 203 of the Companies Act, where the obligation is that he will be treated as a key managerial personnel and appointment will be at a regular board meeting, not by way of a circular resolution. Now, other than that, I don't see that there are any restrictions in the law with regard to appointment. So,
But
interim person will also be a company secretary and will be appointed at a board meeting only. These are the
no, I
two
don't think so. That
requirements.
should be the case, because he may or may not be the company secretary of the company. Because it is nowhere mentioned that the company secretary of the company has to be a compliance officer.
All right. So it means he has to be a company secretary.
He
That's
has
it.
to be a company secretary.
So that is only coming from regulation 6(1).
Yes.
So if this entire sentence that the listed entity cannot appoint an interim person unless the appointment follows the applicable laws for the regular appointment to the position and fulfills the obligation, this still I am not able to understand completely as to why this particular phrase has been brought in regulation 6.
I think, sir, the only thing they were trying to plug is appointment of persons other than company secretaries as compliance officers. That can be the only reason. Because otherwise, there would not be any reason of providing any regulation for appointing any interim person.
Yeah, but Ankit, that is coming from the without even change also. The law says, law was prior to the change was also saying
Sir, but
that companies
companies
shall be
were,
compliant.
but since as you mentioned, for filing and other purposes, and for a lot of places, policies, compliance officer was required. So companies do tend to designate their existing CFOs or some other person as compliance officer in order to maintain the compliance requirement, because the regulation itself doesn't provide any timelines to fill the vacancy. So just for the intermittent or temporary purpose, they used to put some person as a compliance officer, so that necessary filings and all other things continue to take place. Even under, for example, PIT and a lot of places, there was a requirement of compliance officer seeking pre-clearances and other things. So in case if there is no compliance officer, then there would be challenges in meeting those requirements. So
because
to
the similar
consider
language,
all those things.
Ankit, similar language now has been used. If you know, earlier there was no provision with regard to the appointment of even CFO and the filling the vacancy of CFO and CEO also.
Yes.
Now the law has provided and extended the similar provision for the position of CEO and CFO also.
Yes.
And same language has been used therein also with regard to the filling of the vacancy, the interim position. Right? Anyways, I think we can move on and
We can move
Okay.
on because
So then moving on to the next requirement under Regulation 17, which says that for all approvals of appointment, the appointment or reappointment of a person on board of directors, next meeting, which is earlier, approval for continuance with effect from the continuance of a director serving on the board of directors of a listed entity must be approved by our shareholders in a general meeting at least once every 5 years. And directors who are serving as of 31st March without shareholders approval for 5 years were required to be approved the first general meeting held after March 31st, 2024. And this requirement will not be applicable in respect to the directors or whole-time directors, managing directors, independent directors, or directors retiring by rotation who are subject to shareholders approval after a predefined period. And so the requirement of shareholders approval is with respect to the directors who are on in terms of a permanent role on the board, which are basically non-retiring, who stays there for a long period unless and until they finally decide from themselves to leave the company. For such directors, Now there is a requirement that you have to seek the shareholders' approval every 5 years.
Yeah, I think this is a welcome change because a lot of companies were having even the promoter director also to the non-executive position, and they were sitting on the board as a permanent member. I think SEBI has rightly catched those provisions and plugged the loophole.
Anything where you feel there is a gap which needs to be filled?
Sorry, Ankit, I missed out.
Do you see there is any gap which still remains to be filled in the regulation? Any area for interpretation where you see
No, there are other points. If I go for a specific case, I don't know whether we have that much time or not. Let us take the case of banking companies or the banks. Now, where they are taking...
Amit, we have to be because
Yeah.
we can take up the case, but the topic is
No,
too
I just mentioned for the thinking of the participants, see what could be the situation. Because in banks, what is happening, there are the positions of director which are elected director, not appointed director. Now, the regulation which says that you have to take the approval of shareholders. And there is a condition that where the elections are taking place, the government or the promoter cannot vote. And otherwise, the requirement is that it has to be a special resolution. So how both of these conditions will be fulfilled, whether government to vote or not to vote, how the harmony will be created is a little challenge, or government has to come out with the waiver for elected director. I just wanted to bring the small point.
But these elected directors must be having some tenure.
Yeah, they have a tenure of 3 years.
So I don't think this will apply to anyone who is having any tenure.
Not exactly related to this particular point, Ankit, but
Okay.
Otherwise it says that you have to take the appointment of approval of shareholder also separately. No?
Okay.
So from there we will be getting stuck. We'll discuss that because that may not be concerning to many.
Okay. So moving along, next change is with respect to the vacancy in the office of the director. Which will be have to fill from 3 months from the date of the vacancy or immediately, where the vacancy results in non-compliance immediately if it results in non-compliance with the composition requirement of the board. So any vacancy which is of intermittent nature, which cannot be controlled in office of any director, because for independent director this already timeline of 3 months is prescribed. So if there is any such vacancy, it has to be filled within 3 months. But if the vacancy was predefined and there was a fixed tenure, the director, non-executive, non-independent, was supposed to retire at a particular point of time on account of completion of the tenure, then the period of 3 months will not be full granted to comply with the requirement of Regulation 17. Though the requirement of filling the casual vacancy will not be triggering in case after the cessation of the director, the board continues to function in accordance or in compliance with the requirements like down under Regulation 17. So similar to independent directors.
Yeah, Ankit, I guess this exception or this provision has been inserted to just as a saving clause, because for all cases for independent director, for other positions, they have already provided the timeline for filling the casual vacancy.
Yes.
Right? But if there is any, because in certain situations, many of these answers were not available. So they have provided a general clause also. Any vacancy, if it is resulting to a non-compliance, will be required to be filled in. As you rightly mentioned, vacancy means it has to be a vacancy, not a retirement or coming to an end of a tenure, which is predefined.
So similar to compliance officer, now 3 months time has also been prescribed for vacancies in office of CEO, MD, WTD manager or CFO. And similarly, there can also be not an interim appointments unless the interim appointments meet the conditions of the original appointment. So similar to compliance officer, the timelines have been synchronized for all the key MPs other than compliance, company secretary, CEO, MD, WTD manager or CFO.
Ankit, only point that small point, there is no charging provision for appointment of CFO.
Yeah.
As such. though there is a provision inserted for vacancy.
Sir, even I don't think, as far as I recall, there is also not a specific charging provision for appointment of CEO or MD.
Yeah, CEO and MD also, correct.
All these are
also
appointments
not.
are driven from the Companies Act only.
It looks like, but because now LODR is applicable on the entities as well. So in many of these other cases, these appointments are not mandatory. If somebody has appointed, a question comes, if law does not require me, so should I fill the vacancy or should I leave it?
So Ankit, one more thing will also be there because sometime what is happening, there is a company which is in a remote area and you can't find people for this. So that is also another problem which they, no doubt, some people were taking advantage of situation the person is not getting, but remote area there is a problem. So how to solve this problem?
For as
And
of
again,
now,
Pawan sir, as you have rightly mentioned, here also the same terminology still that is open to interpretation to my mind. Now, which says that unless the appointment follows the applicable laws. Now, for appointment of CFO, there is what is applicable law?
yeah,
Now,
nothing.
you need not be a chartered accountant or something. It can be anyone. Now,
Yes.
now, how to read that? Why the government has prescribed this? Still is unanswered to me.
And sir, what needs to be looked into, even under, I think, Companies Act also, qualification of CFO is not provided.
Nowhere.
And it says follows the applicable law. It also doesn't say follow the applicable regulations of SEBI LODR regulations. So
Correct.
it intends to cover the eligibilities or other requirements provided under other laws for that particular position, and then you have to comply with those requirements in order to categorize even as a person as an interim CFO.
But in the meantime, suppose Ankit, Amit or Anjali, ye batao, in case there is no person, then in the period interim, who will be the interim person? To whom we can appoint an interim person?
Sir, CFO
No,
can
that
be
is
anybody
the
can act as a CFO.
Ankit, I agree, but the way they have mentioned this particular provision, either they should add a if any word after the applicable laws, right? Then I think solution may be there, right? I can take the interpretation that I can appoint someone else as a interim CEO for that position, right? But otherwise, maybe if I have to sign the balance sheet, or there are n number of activities where the management may like that no, CFO should sign the document. It will lead to some difficulty.
So
In case under applicable law there are no eligibility, nothing is provided, then I think we need not to worry. It aims to I think cover those laws, for example, banking or any other law where there is any other applicable law where there is a specifically identified eligibility for these appointments. Then it has to be in compliance with those. If it is none,
Ankit,
then it is none for everyone.
Worry is only that 2 years later, some new interpretation should not come from the regulator, which me and you
That
are
is
not
always
able to
open for regulator to interpret and issue FAQs.
But I feel for a CS there is a different requirement as compared to all these other positions. Because anybody can be appointed during the intermittent period. There is no specific qualification for these persons. And likewise, during the interim period, if an organization feels that a director of finance should be given the responsibility of a CFO as well. The only thing is that his or her appointment has to be as per the provisions which are applicable to the original appointment.
Okay, and what about the person who has resigned before 28 June? Old applicable law, or 3 months or 6 months? What will be applicable?
3 months, sir.
Why? The person resigned on
for existing persons, because I think under the LODR doesn't provide any specific timelines. So under the Companies Act, there is a timeline of 6 months. So since this regulation will only be effective from 15th July, as of now, I think it would be 6 months only.
Yeah, that's right. It should be 6 months because he has resigned before this law has come. Okay, next.
Okay, moving along. Now disclosures of cyber security incidents, breaches, loss of data has to be disclosed in the quarterly CG report. I think these incidents have been increasing over a period of time. We keep on finding these in newspapers, otherwise that there are some ransomware attack, malware attack, or cyber security incidents, and these are critical in terms of the company in which they are happening. The level of criticality will definitely vary from company to company, and therefore that is they have also mentioned being necessary for investors to understand associated risk and impact, and therefore they have now also introduced the requirement of disclosing this on a quarterly basis in the CG report that is filed with the stock exchanges after the end of the quarter. So any kind of important is any kind of cyber security incident. It is not clearly defined what actually would be a cyber security incident. Any small server creating issues because that would also be a cyber security incident. That also needs to be informed. One need to consider that while complying.
Ankit, the intention is not that you have to inform everything. Information is that cyber security attack means something seriously is affecting. Suppose some bug has come. It is not, and you are thinking that this is a cyber security attack or bug. You can't differentiate because you're not expert on this. So I think something which is affecting the system and it is defacing their website or some other internal system has taken place, which is creating that you have to inform, otherwise there's no need.
Okay. So moving along with Regulation 30, Para A, Para B and C, we are already aware. Para B and C, there is a change. They have introduced a new criteria of quantitative disclosure in order to ensure, while all the companies do have their own materiality policy, but in order to ensure uniformity in disclosure, everyone should consider same set of parameters to determine the materiality. The result or outcome of the materiality criteria may differ from company to company, but at least the manner in which the criteria are being considered and the final outcome is derived is on a similar formula which is applicable across industry on case of a listed entity. So there are three parameters: turnover, net worth, profit and loss. All are consolidated. 2% turnover, 2% net worth, 5% of the average of absolute value of profit and loss after tax on the three audited consolidated financial statement. So we discussed this. Amit, we discussed this. I think your view, you can add on what you think on the absolute value of the profit and loss after tax. We discussed last time. The opinion was that whatever the values for last 3 years, we have to consider ignoring the plus and minus and do the average and take a 5% out of that. In case you have any different view.
No, I agree. That is the only way we have also put our head to understand what could be the meaning of the absolute value. That one view that, as you rightly mentioned, I think that view can be taken unless SEBI comes out with some further FAQ to give us clarity. But otherwise, I agree. We have to go with this way only.
Okay. In terms of disclosure timelines, I think there is a slight variation with what we mentioned last time. I think on the 30 minutes, we mentioned that only the disclosures which are required to be implemented as per Schedule 3 in 30 minutes needs to be informed to the exchanges in 30 minutes now. But as from the correct reading is all the board decisions needs to be disclosed within 30 minutes, and except for those things for which a specific timeline is provided under the Schedule 3 Para A, Para B. So all these needs to be disclosed on 30 minutes, and then the 24 minutes have been divided into two categories: 12 hours and 24 hours. 12 hours is with respect to the event information emanating within the listed entity, and if it is emanating outside the listed entity, it would be 24 hours, though it would be subject to various interpretations in terms of what is emanating within the listed entity and what is emanating out of listed and outside the listed entity. And you will find a lot of variation in companies doing such intimation. Some might be doing in 12 hours, some might be doing in 24 hours. So some kind of guidelines on this can help in ensuring the uniformity in timelines of disclosures of 12 hours or 24 hours.
So Ankit, 30 minutes and 24 hours, I don't think there is any confusion. The dilemma is between 30 minutes and 12 hours. Because
Sir, एक तो चीज clear है ना कि 30 minutes तो anything which is decided in the board.
Correct.
has
Now-
to be disclosed in 30 minutes. So that is
Now-
now apart from board, which is not decided in the board, but an event has triggered.
So you mean to say anything and everything which is emanating from the board has to be disclosed to the stock exchange within 30 minutes of time,
Yes.
right? And rest all things which are emanating from the company but not from the board
Yes.
will be having a window of 12 hours.
Yes.
Where let's say the board has delegated a power to the director,
Hmm.
and director has now exercised a particular power, and
Yes.
it has triggered a disclosure.
Yes.
So the moment it has been decided by exercising the delegated power,
Yes.
from that time the 12 hours time will start.
Yes. You have 12 hours.
All right.
There can still be a lot of confusion with regard to 12 and 24 hours. For example, although the examples given here are fire or suspension of production, if the fire happens in a factory way in Andaman, then what to do? If it comes to the noting of the compliance officer at 12 in the night, there can be a lot of variations, and SEBI, I think, should come out with some clarification as to what all would fall within the ambit of within the organization, within the company, and from outside the company.
No, I think idea is that where the entity is supposed to have a control or knowledge, where the entity is not supposed to have, like the examples what have been quoted, like regulatory action. Company is not aware whether any regulator will pass any adverse order or not, or court order will come or not, right? So from that perspective, I think it is okay. We can understand where the company does not have the controlled 24-hour window is available. But for the matters which are in control, like maybe yes, fire or suspension of production or getting of some orders or something, all those things may be coming from third party, but having an impact on company. Anjali, what you think, whether they will go on 24-hour window or 12 hours?
I think anything which is outside from the generating outside the company, like a regulatory order, I think it would be 24 hours.
All right.
Because it might be possible it has received at the regional office or some other far-fetched office, then coming to the main head office, being looked into, analyzed. I think there you need certain time to disclose and make a correct disclosure. 12 hours in, I think such cases will be a little challenging.
Yeah, I agree.
So moving along, disclosure of material events in mainstream media. This was there in the discussion paper along with other things. And as per which any reported event or information in mainstream media, which is not general in nature, indicating that rumors are circulating of an impending specific material event or information are circulating amongst the investing public, the listed entity is required to deny or clarify the same within 24 hours of reporting of such event. Mainstream media is newspapers registered with the registrar of newspaper. News channel means MIB registered news channels. Content publishers are like online news agencies, online news aggregators like InShorts, Daily Hunt. All these things, all these newspaper, news channel, content publishers are both covered in and outside India. It's one of the most important in introduction, because earlier there is a requirement of the obligation was cast on the company to voluntarily either deny or clarify any such information is there under the regulation regulation 30. And now they have added a proviso to that on certain class of listed entities, top 100 from October 23 and top 250 from April 24. Then they have to specifically, mandatorily under obligation have to clarify or deny any such rumor or information which is circulating amongst investing public in mainstream media.
Ankit, I think there are two important issues in the entire this Regulation 30 of disclosure. One is how to collect all the information, because they are talking about in national and international both. Okay, that is one part. So you have to have a robust system to get all the information. And second is some transaction where you are entering and doing subject to due diligence, and then you are implementing it. So if somebody is asking you, like newspaper is giving always that there is some transaction going on, you are not in a position to accept it or not to accept, because if you are accepting it, means transaction has taken place. But you are your transaction will take place when the entire due diligence is completed. Then you can say this type of transaction will get some problem. I think how to face this: first you have to deny, and then you have to accept, and then you have to show this, that yes, I was doing this transaction, but it was a condition of subject to due diligence. I think these are the two issues. Yeah.
Absolutely, very big challenge. Pawan sir has very rightly articulated this problem that the corporate is going to grapple with, the transaction like acquisition, where you have the deal on and the due diligence process is now undergoing, and you cannot disclose the name of the entity that you are in process of acquiring, and news media may have published something. Now, how to deal with that in the reply, I think, is going to be a big challenge.
But Pawan sir, what you are saying that you first deny it and then you accept it.
Yeah, Anjali, there is no choice, because suppose I am saying yes, transaction is going on, it means I'm confirming, and suppose the transaction is not able to complete because of some due diligence, then what will happen? So the point is, the conclusion of any transaction, positive or negative, you can say when everything is in place. But on the basis of some circumstances, you can't say. Suppose you are acquiring a company and some news has come in the market. So what will you do? You will say, yes, I'm doing, the market share has gone up. And then you are denying that transaction has not taken place. So the people will take advantage, some of the negative type of person will take advantage of that situation.
Like what we advise to the companies?
You should advise to the company to first say no, if it is subject to due diligence, and if the due diligence is final and everything is final, every transaction rate is and everything is final, then you say yes. And then, but only thing is you have to show your conduct, that whether your transaction, your agreement, your non-compete agreement, or whatever it is, NDA, it was on the same line.
Sir, but one problem I can see, that as soon as you say that yes, the transaction is on, the industry will understand about the disclosure which you have not yet made under Regulation 30 with regard to the acquisition, which you were supposed to disclose, but you have not disclosed because the terms are not yet finalized. So your term will be finalized maybe after completion of due diligence. But by giving a reply to the rumors of the media, to the stock exchange, you will in a way give a clarification that yes, deal is on. I think a very, very catchy situation.
No, Namit, there are so many transactions where they have not finalized, and it has not seen the light of the day because of some issues. So the point is that we must understand that if I'm saying no, transaction is not going on, or if you are saying I can't deny, I can't say yes, the market will react. Only thing is, it is for market. And suppose this is not final, then how can I move it? So in my opinion, if somebody is asking, I will say no, but I will keep my documents ready. that
No,
it
no,
was.
Pawan sir, I'm saying,
But sir,
let's take Anjali just a minute. I'm saying, let's say news publishes tomorrow that ABC Limited is acquiring PQR Bank, right? And I have to counter. Now deal is on. I'm doing a due diligence of PQR for acquiring that bank. Now, if I say yes, deal is on, that means market will immediately understand whatever has been published is correct, and it will confirm the news. That means, in a way, I am giving a regulation 30 disclosure prior to the due time when it was supposed to be given.
Yeah, that is also there. Yes. Let's move on.
another
Yeah.
alternative to this situation is when you're wanting to acquire a company which is subject to due diligence. So you make a simple 2-liner disclosure that the company is exploring options, because it will definitely be a problem wherein you say no first and then within a month you accept that transaction. That transaction is in news. So a better alternative is to give a 2-liner disclosure, as in when things finalize, make a detailed disclosure.
Yeah,
So that
you
if
can,
something
you can
comes
do
up,
this.
you are
Yeah.
in a position to answer.
Ankit, please fast because अभी NBFC में भी काफी है. So just to go for.
So next is with respect to the regulation 30A that has been introduced concerning agreements binding listing entities. So if there is an agreement on one side or both the sides, there are shareholders, employees, promoters, promoter group entities, related parties, KMP, director. On then there other side, it can be these persons or can be listed entity or can there be a third party. And the purpose of this agreement is to impact the management or control of an entity, or to impose restrictions or create any liability on the listed entity. In that case, there is a requirement to inform the same to the stock exchanges under 5A of para A of part A of schedule 3. And in case there are existing agreements existing on the date of the notification of the then within 2 days of the respective person who are party to the agreement are required to inform the same to the listed entity. Details of such listed entity agreements are also required to be disclosed either in the financial statement of 22-23 or 23-24 as the case may be. So this is the requirement under regulation 30A. One thing is with respect to the question apart from the management and control. First of all, how we'll see what would impact the management. So for example, right to appoint one director on the board, can it be said to be a non-executive director? Can it be said to be anything which can impact the management? Or with respect to creation of liability, can any liability be created on listed entity or by way of an agreement entered by two parties to which the entity itself is not a party? Amit sir, Anjali ma'am.
Yeah, liability in the sense that let us say it is a shareholders agreement, and by virtue of shareholders agreement, you are entering into some sort of arrangement which impacts the listed entity also. So possible to answer to your last part that yes, it can create, add or reduce the liability of a listed entity.
No, in your case, listed entity is party. What can be the scenario when listed entity is not a party?
So even listed entity is not a party, I believe still it can be a possibility where you are representing, you are a director, right? As a director, you are making an agreement with some third party. So third party is protected by virtue of your agreement with the doctrine of indoor management. Whether you have authority or not, that's a separate matter, but you can certainly create the liability on behalf of the listed entity, I think.
But in that case, you will not disclose, because then it would be an agreement beyond your authority. I don't think you would be disclosing such agreements.
No, even if it is within authority, you have
Within authority, you will not be able to bind unless and until it is approved by the board or you've been authorized. Because director then would be entering the agreement in his individual capacity. If he's entering on behalf of the board, then it's an agreement to which a listed entity is party.
Yeah.
But Ankit, the intent is which is impacting the control and management of the company. Achha, okay.
Clause B, second clause.
Okay.
So this is something, and now also with respect to the management or control, for example, if a promoter is owning 25% and he enters into an agreement where on occurrence of certain event, he will sell his entire shareholding to another person. So will that tantamount to impacting the control? Because he was never actually in control, might be the largest shareholder as a promoter, but not necessarily impact the control, and then may create an impact on the management. That also is very subjective.
There can be a situation to it wherein I, as a promoter, pledge my holding or take a loan from any of the persons, anybody else, and I pledge the shares of the listed entity. If I do, I'm not able to pay off the loan. The pledge would be invoked by the bank or the lender, and there would be an impact on the control of the entity. So this is one situation which is envisaged here.
But when you were not yourself in control with just 20% as a promoter, 50 beyond 50 it is clear. But if you are as a promoter holding 25% or 30%, and you pledge your shares in such a situation which you just outlined, and it will go at a particular stage,
But with
will you see that as a change in control?
no, yes, even as 25%, only 24% holding. I was in control of the company, but then 24% going to somebody else who may be a competitor as well. So that is what is intended to be covered here.
No, so if you are saying so long you're 24, you are saying you are in control of that organization, then definitely it would trigger a requirement of disclosure under this regulation if the situation that you have outlined. The question is whether it can be said to be 24% promoter is in control. Logically, it would be in terms of being the largest shareholder. Legally, whether he would be in control or whether he would be exercising significant influence is something. Amit, what is your view?
Yeah, I agree. I think something more needs to be deliberated. Definitely, it is a open gray area. The point that you are raising, I can understand, but no immediate answer to that. Whether because it's very situational. If I say that no, when the person will be having only 51%, then only I'll treat as a control. That is also not correct situation. So even with 24% holding, also there can be a situation of a control. Control has to be understood in a general parlance, where the person who takes all the shots with regard to the decision making. I think if that condition is met, irrespective of holding, the control will be established. I think that's how we will take it.
Ankit, Amit, and Anjali, this is very clearly mentioned that anything which is affecting control or restricting the liability, because you can't restrict the listed company for anything. So anything which is affecting, you have to disclose. That's the one part. Somebody is asking this question. There is a confidentiality. Okay. So these types of things where control is changing, where binding is there, when restriction is there, liability is imposed, then there's no confidentiality. Even this is confidentiality between the party and the company. But you can't do this if it is coming into that category. You have to disclose.
Yeah, the question is not about, I think disclosures are definitely confidentiality cannot overrule the requirement under law. What we were deliberating is to what extent and how we'll determine what is control and what tantamount to change in management or impact the management.
But impact, the change of management control is defined. So as per the definition of the change in control, that will follow. Whatever the percentage, whatever the decision making, that will be the change in control. So I don't think we have to see between the lines. We have to see the law, what law is prescribed, and then impose restriction or create any liability. This is the question, that how much, what is the liability and how much liability is there. First part is very clear, that is defined in the law. Follow that.
Okay. Next is with respect to special rights. So any director holding special rights, any shareholder holding actually special rights shall have to be mandatorily approved by the shareholders by way of special resolution after every 5 years, which are already possessing such special rights. They have to comply with this notification within 5 years. The only question is, most of the rights are generally form part of the article of association in most of the cases. And in whether I need to obtain the approval of shareholders in all these cases too every 5 years.
Seems like that only. Unless there is some clarification, that looks like the intent.
And okay, going along to next. BRSR. So the press release which was issued by the SEBI board meeting, and I think the discussion paper before that, outlines a concept of business responsibility report core that will be introduced as part of the amendment in the BRSR circular, which has not been come out yet. So there will be a requirement of all the entities who are supposed to prepare the BRSR report core, and they have to obtain assurance of these the items which are outlined or disclosed in the report core in such manner as may be specified by SEBI. And then the entities which are preparing business responsibility sustainability report core, they or will also be required to obtain certain assurances with respect to their value chain partners in such form and manner as may be specified by SEBI. The term value chain has also been defined by SEBI. Analyst investors meet. So now they've introduced a new timeline, both for intimation to the exchanges and for also posting on the website. So at least 2 working days in advance, excluding the day of intimation and the day of the meeting. In case you are holding any scheduled analyst or institutional investors meeting, it has to be posted on the website and also needs to be disclosed to the exchanges. Currently, there was a requirement of posting the transcript, recording after holding the analyst call. Now, specifically, a timeline has been provided.
With regard to the website contents, recently only a very renowned listed company has been imposed with penalties of approximately 30 lakh rupees. The violations were with regard, the lapses pointed out by the regulators are with regard to many of the provisions, wherein one of them is regulation 46 as well. That is the website of the company. So I think every listed company should be very careful about as to the contents which are appearing on the list website. There should be a proper tabs and proper links on the site wherein the disclosures are appearing. Because now regulators have started giving attention to the websites as well.
Thank you. Now moving along to the SEBI board meeting. You like to take this?
No, you take it.
Okay, so now SEBI has, as part of the board meeting, there was also a discussion paper where they've reduced the timelines for shares and initial public offer from existing 6 days to 3 days. And the revised timelines of T+3 will be applicable in 2 phases, voluntary for all public issues on and after September 1st, and then mandatory after December 1st. So there would be faster listing. You will be getting a faster allotment of shares and then faster unblocking of your money on account of SBA. Then having outstanding listed entities, amendments to LODR regulations require listed entities having outstanding listed NCDs to list their subsequent NCDs at the stock exchanges. So this new requirement will come into effect from January 1st, 2024. So is aimed at facilitating transparency in price discovery of NCDs or currently listed in case they have to list at the stock exchange of their forthcoming NCD issue. Then there were certain disclosure amendments with respect to portfolio investors. Since the Adani fiasco, a lot has been discussed in terms of the disclosure requirements of ultimate holders for these foreign portfolio investors and SEBI has been doing a lot of discussions on these. So the SEBI board meeting finally approved the amendments to the foreign portfolio investors and prescribed for high degree of disclosures to certain class of foreign portfolio investors, including details about ownership, economic interest going forward. Then the investor grievance handling mechanism was also approved. The new platform, there is a concept of online dispute resolution mechanism that has been introduced, where it will also be linked with the score, so will result to faster redressal of the investor complaints. Amit, any thoughts on the FPI amendments?
Not exactly. I think.
Okay. Now I'll ask my colleague
So,
Devashri.
Yeah, Ankit, it's okay. So now all the amendments related to SEBI and LODR we have covered. Now there are some regulatory update on NBFC's regime is also there. So we'll request Devashri Das to just cover up. Time is short, so we have to be very brief. Devashri.
Thank you, sir. Thank you for the introduction earlier. And really, am I clearly audible?
Yes, you are audible.
Really a privilege to get the opportunity to speak after such after all the seniors and learned speakers. So I'll be quickly covering the changes that have happened in the last month with respect to NBFCs. So there were two major changes that the entire industry was somewhere waiting for, which came in the month of June. The first one was with respect to the clarity on the FLDG guidelines. So a quick background, since everybody knows who is dealing with this sector, that last year in the month of August, when the working committee on the digital lending, they came up with the report with the recommendation that FLDG agreements or FLDG arrangements should not be encouraged and they should be stopped. And they also recommended that even if it is allowed, there should be some capping on it. So post this recommendation, the entire industry, all the agreements which were there had stalled. And for almost a year, the entire industry, the NBFC in the fintech industry, primarily, which basically works on this FLDG model, they were awaiting clarification on this guideline. So on June 8, the complete directions, guidelines have been issued. And so it starts with so there are a couple of so since these are the first guidelines, and the only reference that can be sought when reading this guideline is the digital lending guidelines, which came in the month of September last year. So these guidelines have sort of enumerated the provisions from the scratch. So it starts with the applicability. So it is applicable on all the commercial banks, all the cooperative banks, all the NBFCs, including HFCs. Next, it talks about, it gives the concrete definition of what is a DLG, what is a default loss guarantee. So this default loss guarantee is nothing but a contractual agreement wherein a regulated entity, which are all the three above mentioned, they are compensated for default loss up to a certain percentage of its portfolio. So so generally it used to happen that all the fintechs who were partnering with the NBFCs, they used to provide a certain guarantee, a percentage of guarantee for the loans that were being sourced by them. So the basic intention of doing this was nothing but just to be a part of that lending ecosystem, wherein a fintech which is not an NBFC, registered NBFC, still wanted to be a part of the lending ecosystem, and it used to source loans, and it used to say the NBFCs that, okay, I'm sourcing these loans and I'm providing a guarantee also in terms of this much percentage, that in case, since they are sourced by me, so I'll bear the cost or bear the expense of it in case the loan gets into default. So that was the basic premise of this entire DLG arrangements. Further, moving on, the guidelines also talks about, it specifies what exactly an arrangement means. So it says that an arrangement is something which involves default guarantee with which it has entered into an outsourcing agreement. So this is talking about, and further it says that a DLG arrangement is something that has to be entered, that can be entered only with an LSP or with another RE. RE, which means all the three mentioned above. So this DLG arrangement earlier, of course, this is something, not a major change from what was already happening in the industry. So the LSPs are the loan service providers, which generally are the sourcing agents in case of a fintech. They used to provide guarantee to the NBFC, stating that this percentage of loan is being guaranteed. So these DLG arrangements are making it precise or concrete in the sense that only if an agreement is entered with the LSP or an RE, only then these DLG guidelines and the foregoing provisions that are contained in this will be applicable on such arrangements. Moving to the next slide. Can we, sir, can we move to the next slide? So
This is fine.
Yes, sir. If you can just
Yeah.
go back. So further, it says what is an LSP. So the definition of LSP is taken from the digital lending guidelines, as I mentioned earlier, which came out in September last year. So it says that an LSP or a loan servicing provider is somebody who offers or who carries out the lender's functions in terms of customer acquisition, pricing support, monitoring, recovery, etc. So these are certain activities which generally companies or NBFCs outsource, or they enter into tie-ups with other entities, the fintechs and other, even apart from fintechs, who offer such services. So these DLG guidelines are primarily, these are the entities. The entities who are offering such services like customer acquisition, pricing support, monitoring, recovery, or any other activities which are defined in the guidelines, which basically help the lender to carry on which basically carries out the lender's activities in terms of the entire loan cycle. Only these entities which are classified as LSPs. So the DLG guidelines or a DLG agreement per se can only be entered by between an NBFC, between a regulated entity and these LSPs. Now further it talks about what are the different forms of loan guarantees that can be provided. There are three which have been classified. The first is cash deposit with the NBFC, wherein a certain, of course, given the portfolio, there is a certain, the amount and the thresholds are already defined. So a certain cash deposit is already, even before, just by entering into an agreement, even before the loans are started, even before the loans have started coming back, a particular amount of cash deposit is given to the REs, so that in case there is any default, even with the first default, that cash deposit can be utilized to refill or to compensate for the loss of the loan or the repayment that has happened. Second option that has been given is a lien mark FD in a scheduled commercial bank in favor of the regulated entity. That is one. That is second. Third, it talks about a bank guarantee that can be given in favor of the regulated entity. So these are the three options that have been specifically defined. Any option apart from, these are the only three options that are available. Any arrangement, any form of DLG outside these three will not form a part of the DLG guidelines. Then another interesting thing that has been highlighted in these guidelines is the capping on 5%. So the guidelines talk about only 5%, but it is inherent that this 5% is only on the outstanding portfolio. Because if it is a revolving portfolio, then in that case, the amount of disbursement cannot be the determinant to calculate this percentage. So it is at any time on the outstanding portfolio. Then moving further, it says that the guidelines on the the treatment of the regulatory capital. So these treatment, so for regulatory capital, as we all know, NBFCs have to define there are different risk weights that are given to the various assets that are in the balance sheet. So in case of default loss guarantee, which let's say an NBFC is taking in form of a cash deposit or something, then in that case, whatever existing norms have been defined in the master directions, only that will be applicable. There is no change in it. Earlier also the NBFCs and the regulated entities were following this practice. Invocation earlier there was no period defined as such. It was up to the REs and the LSPs per se to define as per their agreement, as per their understanding, that within how much period they will be invoking the FLDGs on the other party. But now it has been restricted to, it says a maximum of within 120 days it should be invoked. Further, it talks about disclosures. Earlier there were other based on the existing outsourcing norms and other things, there were restrictions, or there was a liability at times in terms of defining that what all activities an LSP needs to take. But now it has been clearly defined that an RE should ensure that the LSPs, that is the person who is giving the guarantee, on their website they should disclose the total number of portfolios and the respective amount of each portfolio on which the DLG has been offered. Second, the last point that is covered in this guideline is the board approved policy, which is a prerequisite. It says that a board approved policy should be there in place, and there should be it should cover the minimum eligibility criteria of the DLG provider, and it should also cover the nature and the extent of the DLG cover. It should also highlight the process of monitoring and how the DLG arrangement is being reviewed from time to time. It should not so happen that let's say for an entire loan tenure of 3 years or 4 years, the equivalent duration for which the DLG arrangement is entered, it should be kept on reviewing. The NBFC, the RE should particularly devise a mechanism wherein it keeps on reviewing it on some periodic basis, so that the invocation at the time of invocation, whatever policies and whatever practices, whatever steps had been mentioned, they are during the entire tenure of the agreement, they are closely monitored. Then of course the details of the fee. These are a few components that should be there in the policy. Then moving to the next. Last 2 points quickly I'll cover. It says a declaration from a DLG provider needs to be taken. So this was earlier open as per the RE's discretion, whether as to how they would want to determine the capacity of the entity who is providing the guarantee. But now it has mandated in the guidelines that any RE who is entering into a DLG agreement, so from the DLG provider, which is a default loss guarantor provider, the RE needs to take a statutory auditor certificate which mentions the outstanding number of and the total number of REs in respect of which, and the portfolios in respect of which the DLG has already offered guarantees. This is nothing but just to determine the capacity, the overall capacity of a DLG provider in terms of providing guarantee to all the entities with which it has entered into such arrangements, because it might enter into multiple entities. It might enter into an agreement with multiple entities. So it has clearly specified now. Further, one exception is there, which says that there are various guarantee funds which are in place. SIDB, which are SIDB, Mudra, they have a lot of credit guarantee funds they provide to NBFCs and banks. NBFCs particularly for priority sector lending and few categories of lending. So the DLG guidelines will not be applicable on them. For the simple fact that they have their own pool, they have their own arrangements. So these guidelines per se will not be applicable on such funds. And also it will not be applicable on the IMF, on guarantees which is provided by International Monetary Fund and the Bank of International Settlements, as well as multilateral development banks. So it will not be applicable on these. Moving forward, can you just go back? There is one small thing that I think it has been, there was a typo in that case, even in the slide previous to this, before. one more slide. So this cap on DLG, which I had mentioned, so this 5% is typically not on the outstanding portfolio. This is on the total disbursement. Sorry for this, there's a small typo. So this is basically to ensure, let's say there's a 100 crore portfolio and it goes on depleting over the time. So the 5% has to be fixed on the amount of the disbursement. So whatever, even if it is going on around, even if it is, even if there are multiple cycles or it is being rolled on for multiple future other events for in other subsequent tranches, the total percentage needs to be fixed on the total amount or the pool rather, which has been defined by the which has been defined in the agreement. So these were all for the DLG guidelines. Another amendment that came up was the compromise settlement and technical write-offs. So these were again a new thing for the NBFCs. Of course, there were guidelines. There was a prudential framework which came back, which was there in place way back in 2019. But with respect to NBFCs categorically, it was covering only the systemically important NBFCs. And that too to the extent of those arrangements which were wherein NBFC was just a part of the, was just one of the lenders. Even only in that case, those prudential norms were applicable. So now these have been, of course, it does not need to be read with the prudential framework. Prudential framework is something which is still in place. And of course, there have been, during the time of COVID, there were certain windows and exceptions that were given to the prudential framework of 2019. But apart from that, as on date, the original prudential framework 2019 is still in place. And this compromise settlement and technical write-off, the new framework, is basically just to provide, is to cover all the entities which were earlier out of the purview of the prudential guidelines. And the other reason of why this came out was, of course, one of the major reasons was the frauds and the willful defaulters were earlier not covered under the framework. So now even the parties which have defaulted, willfully defaulted, and who are covered under frauds as per the other existing master directions, even they are covered. Even the settlement and technical write-offs guidelines can be extended even to them. So quickly, the contents have been mentioned in the foregoing slides. The first is, which is applicable on both compromise settlement and technical write-offs. So if I can just go back a slide, yeah. The first slide of the compromise arrangement. 4 slides back. Yeah.
So this is the first slide.
Yes, so that's it. So this talks about, this covers the entities to which the technical write-off and the compromise settlement is applicable. It covers commercial banks, all the cooperative banks, NBFCs, including all the HFCs, and all India financial institutions. Further, it has clearly defined the compromise settlement and technical write-offs. So compromise settlement for the purpose of these guidelines would mean the negotiated arrangement, any negotiated arrangement to fully settle the claims in cash. And it may, of course, entail some sacrifice on the part of the RE. As in, it cannot happen that it is recovering the entire amount in one go. And there should be some sort of sacrifice on the part of the RE. That is when it will classify as a compromise settlement. Further, it has defined technical write-offs also, which was earlier not defined anywhere per se for NBFCs. It says that cases where NPAs are outstanding at borrower's loan account level, but are written off fully or partially by the RE only. So this is nothing but just an accounting treatment which NBFCs, which regulated entities have been doing, banks have been doing since pretty long. They used to they just write it off for the accounting purpose, and the bureau reporting and other things keep on happening as per the original tenure of the loan, as per the original status of the loan. Then further, it talks about the next 3-4 slides are about what are the basic things that an NBFC or even a base layer NBFC, since it is applicable to them, what are the things that they need to ensure when they are when they are devising a mechanism for compromise settlement and technical write-offs. So board approved policy should be there in place as the first prerequisite, a process that is followed by the entity that should be clearly defined, a graded framework for examining staff accountability with reasonable thresholds and timelines should also be there. which means that the reason, as in generally it happens in MFI sector or where the rural people is, where the rural segment is being catered to. So where people actually go and there's physical collection of cash. So in that case also, let's say a staff didn't go, so it cannot. There should be a rationale behind whether the delay has happened because of staff, because of the RE internally, or because the borrower or the person who was supposed to pay back was actually suffering and could not pay it for some other reason. So to bring that bifurcation, such graded framework should be there in place. Then delegation of power should be there. An authority which has sanctioned the credit should not be the authority who is, the authority who is sanctioning and the authority who is approving this compromise settlement should not be the same. The one who is approving the compromise settlement should be one level up than the one who had disbursed it, who had sanctioned the credit. Next, reporting mechanism has been defined. At least reporting should be done at least on quarterly basis. Then the compromise settlements and write-offs which have been approved by MD and CEO or at the board level, they should be, or at the committee level, they should all be reported to the committee. They should all be reported to the board. Then formats have been described. They were not there in place earlier. Clear formats of these reportings have been defined, wherein the trend should be covered. Then the accounts which were classified as fraud or red flagged, or they were willful defaulters, they should be classified clearly. Then the amount wise, sanctioning wise authority and the business segment asset class wise grouping should be there of the accounts. Then the extent of recovery in technically written off accounts should also be there. Like, let's say, of the account which has been technically written off, but still it is being recovered. So that reporting should also periodically go as to whether the account which has for accounting purposes been written off, but the recovery is still coming. So the reporting guidelines should cover that aspect as well in detail with the dates and everything, specific amount with bifurcation of whether it is principal or interest. Then another thing, it says that if it is a restructuring, there are cases when it will be classified as restructuring, wherein, let's say, there is any mutually, apart from this compromise settlement and technical write-off, which is being done under this guideline, in case there is any other parallel mutual agreement between the RE and the borrower, and the claims are recognized in the balance sheet of the RE. In that case, it will be treated as a restructuring and it will not be called as a compromise settlement. So the basis for this.
Actually, you have to be very fast and you have to just cover the important points.
Sure, sir. So this is one aspect. Then another aspect which I had mentioned, the fraud, the accounts which are classified as fraud and willful defaulters, they are now being included. They are now being covered under this ambit. Earlier they were not covered. Moving to the next. These are a couple of points which are specific only for compromise settlement. So the delegation of power is one thing, wherein proposals for compromise settlement of debtors classified as fraud or willful defaulters, they should be approved only by the board. So this authority cannot be delegated to any committee or any other person, as it can happen in case of technical write-offs. So it has to be approved by the board for cases where the borrowers are from fraud categories or have been willful defaulters. Then board policy, again, it should mention all the contents in addition to what has been mentioned earlier. Then prudential treatment. Yeah. So another important point is the cooling period, which was not there earlier. So a cooling period of 12 months has been prescribed under the guidelines, wherein a minimum gap of 12 months has to be kept, after which the subsequent credit can be provided to the borrower. And in case of farm credit, this relaxation, this threshold is not there. In case of farm credit, it is up to the board to determine the cooling period in case they want to keep any. That is one. Then moving to the next. For technical write-offs, again, there is no cooling period when it comes to technical write-offs. And in case of when there is a partial technical write-off, generally companies do a full write-off, but in case when partial write-off is being done, then the residual portion that needs to be classified, the prudential requirements would apply on the gross amount and not on the residual amount. moving to the next, these are a couple of differences which I had already mentioned slightly briefly in the beginning, that these are not superseding the prudential framework, but it is somewhere broadening the prudential framework to cover base layer NBFCs as well, specifically talking about NBFCs. Then the applicability in terms of exposure size is also increased. In terms of prudential framework, the minimum threshold, there is a minimum threshold after which the framework is applicable. In terms of the compromise settlement and technical write-offs, with these new guidelines, there is no minimum capping. So any kind of compromise settlement and technical write-off being done by the company needs to be governed by these regulations. Then cooling period, again, there is no cooling period as such defined in the prudential norms. So that is another thing. Then again, fraud and willful defaulters were not covered earlier. This is a new coverage that is being taken. So that's it. Thank you so much.
Thank you. Thank you very much, Devashri. I have few questions, so I can quickly just do this. I'm say technical issue we are not covering because we are not the competent to tell you. This is already covered. Ankit, if the deputy CFO or deputy CEO is also a CS qualified, then there is not issue of appointing him as a compliance officer?
They can be.
Okay. What if the plant and manufacturing site where the fire occurs is located outside India, say in USA or Europe? Then how can we adhere this timeline?
So you have to make those SOPs. These things are not, these things are very critical. If fire happening, it's critical to the company. I don't think it would take 12 hours to reach you out.
Okay. Now there's one comment as per the language of the amended regulation, agreement that are not in the ordinary course of business are presumed to impact the management or control of the listed entity or impose any restriction or create any liability upon the listed entity, and are thus required to be disclosed. Imposing restriction or creation of liability is not be seen for agreement that are in a ordinary course of business. I think this comment is right.
This is mentioned in the regulation itself.
Yeah. Okay. So these are the questions which has come. We have discussed all these questions. Just remove
Not
this.
much questions are there.
Any other question, Amit, you think, or Anjali or Ankit, which is there, which during this 10-15 days you have come across?
One question I went to a client, discussed with respect to the circular resolutions, whether the 30 minutes timelines will apply to a circular resolution. I think when I read it, it appears that it should only apply to a board meeting. Amit ji, what is your view on the circular resolutions?
No, but I think other way, you don't have an exception. As soon as you say the resolution is passed, the decision is taken, I think your timeline will start, whether 30 minutes or 12 hours, whatever way.
It says 30 minutes from concluding of the meeting of the board of directors.
Sorry, come again?
30 minutes from concluding of the meeting of the board of directors.
Means 30 minutes.
Because circular resolution में एक ही challenge है to determine at what point of time you will find it passed.
That I agree. So what will be the consequence now? Instead of putting a date of approval of circular resolution, now we'll start adding a timeline also. Yes, at what point of time we have got the requisite approval. So from that the time will start. Earlier we were not doing in the board meeting also. Now we are doing for a board meeting. I think now the time has come when the circular resolution also should start recording at what time the circular resolution was deemed as passed. That is how I look at it.
Yeah. With respect to the rights of shareholders, there was another question that I dealt with, is where the company is not a party to some shareholders' right, which is actually not a right to the shareholders, it is a right arising out of a shareholder being part of the promoter company. So there is some arrangement between the promoters and shareholders of the promoter company pursuant to which they have rights for appointment in the subsidiary where the listed entity is also a part as a subsidiary, not per se party to that agreement. So will these agree, which these rights will also go, because in this case, this right is not to any shareholder of the company, and it's actually not difficult to say whether that's a right, because company is also not a party to that agreement. It's an agreement between the shareholders of the holding company.
So, Amit, any other point? So otherwise, we can.
So I also received the query wherein the company receives their monthly power and fuel bills, which are now more than the thresholds as prescribed in Regulation 30, Sub-Regulation 4.
Okay.
Now, will they be required to pass these bills, these disclosures will have to be given every month?
Okay.
What is this bill?
Amit,
It will. It's a normal expenditure. It doesn't form part of the listed items in para B. If it's just a bill.
And that's what I also told them. But there are, what I'm trying to say is there are discrepancies.
In the bill.
No, there's no clarification. There are certain clarifications which will have to be brought in by SEBI.
okay. So now, friends, time is, we have tried to cover all these points and we have already exceeded the time. Okay. And now, as you are, thank you very much for all. My learned speaker, Amit Gupta, GP Madan, Ankit Singhi, Anjali, Devashri, those who have covered. Friends, this program is actually this program, the purpose of program is to update you. So it is advantageous that you should ask questions. You should see this, whatever it is there. If it is missed out, you can just update yourself. So thank you very much to all. Thank you, participant. Friends, this journey of sharing knowledge will continue. As you are aware that our next webinar is on 14th June, that is a Friday. And on popular demand, we are organizing this program for the investor point of view, because you are seeing the stock market is on the top. It has crossed 19,000 Nifty, and the BSE index is also, and then 3 trillion market capitalization has crossed of India. So you can understand that everything is on the boom side. So when there is a market boom, then so many people understand, there's so many people involved, and there's so many people want to invest in the market. So we want to organize the program on this, and the topic will be what investors should look for before investing for long-term growth. Now, this topic is not for company law, security law, or FEMA, or insolvency, or any corporate law. This is for everybody. Everybody is investing. Everybody wants to invest. So we want to discuss this issue, and we are called very expert people from the market, those who are managing PMS, portfolio management of various people, those who have invested their own money, and they have their own success story also. So they will tell us that what is the way out to get the good investment where long-term growth will take place. So I request all of you to register, and then 14th June at 4 p.m. we will meet again and discuss this issue. In case you have any query, any point, you please give it to us. So we will prepare and we will ask the expert about this. So thank you very much. Thank you for joining us.
Thank you.
Thank you.
Thank you.